Hey, it's Justin Harvey. Thanks for tuning into the Anesthesia and Pain Management Success podcast. With APM Success, we take a close look at important topics pertaining to business, practice management, personal finance, and careers for anesthesiologists and pain management physicians. We work hard to take your critical questions straight to the experts. Thanks for listening. Hello and welcome to another episode of APM Success. Very pleased to be joined today by one of the OG friends of the show, attorney Scott Weavil, who has been on a number of times to talk about all kinds of things related to transactions and contracts and has been a valuable resource for this audience in the past. Today, I'm excited to be talking about the recent FTC ruling related to non-competes and how that's going to impact physicians. So, Scott, thanks for being here and lending your expertise once again.
Yeah, sure, Justin. Thanks so much for having me. And, it's a very timely topic because I'm talking to clients, as we mentioned before the show, some of whom think that this means that non-competes are just not worth worrying about anymore, which is probably an aggressive reaction to the rule, and others that have a more circumspect stance. So I think it's perfect topic.
So in January of last year, 2023, the FTC issued a proposed rule, opened up a forum for public comment. And this recently came to a head in the last couple of weeks where a final ruling was issued, which is now causing all these lawsuits and things. But give us a little bit of perspective on sort of the story, the history here, and where we're at today on this ruling.
Yeah, for sure. So as you mentioned, I think the initial rule was proposed about a year ago. The FTC went through a notice and comment period. Lots of comments on both sides, employees sort of obviously weighing in favor of the non-compete ban, while, the American Hospital Association and other large employers throughout healthcare came down on the other side. I think, roughly in the last couple of weeks, the FTC voted 3-2 to pass the sweeping final rule that essentially, even in the FTC's own language, bans employee non-competes. I think many of us have been hoping for this for a while, essentially viewing non-competes as being used sort of as adhesive employee retention tools rather than protecting true legitimate business interests. But on the flip side, we do have to remember that this cuts both ways. I know a lot of your audience is pain medicine physicians, a lot of whom own their own practices. Well, as a practice owner, you're faced with building up the reputation of a new pain physician in a new community while you subsidize their income. And then potentially, if you cannot non-compete that person, they could end up working next door to you after you've expended all those resources. So that's something to consider, that there are indeed two sides to this, even from a physician's perspective.
Yeah, one of the interesting things about a sweeping ruling like this, if it does end up standing after the lawsuit's dust settles, is that, it's a swinging pendulum, and it's going to create a whole new swath of problems that didn't exist before that are then going to be in the whack-a-mole of policy and business practice. Like, what are the signing bonuses going to look like? What are the employment agreements going to look like 2 years from now? What is if it's much easier to leave, there's probably going to be some economic trade-off embedded in there and lots of other complexity that it's difficult to even anticipate. So I'm interested to see how this all shakes out.
No, absolutely. I think that's true. And just so we do not forget this, as we discuss later, if to the degree the rule is invalidated, remember, we still do have state rules. And then to the degree that the rule is upheld, remember that there are other types of restrictive covenants, such as non-solicits, confidentiality, and proprietary information provisions, and things like that. So it does not mean that the playing field is totally clear if the rule is upheld.
Can you take what you just said and sort of describe it in a little bit more detail so our listeners understand what you're talking about?
Yeah, sure. And does it make sense to go over the rule just to provide a little bit of a basis for what we're talking about?
Idea. Let's start there.
Okay, so first, it bans non-compete. So let's first talk about what a non-compete is. The FTC defines a non-compete as a term that prohibits a worker from working in the United States for another person after the conclusion of employment, or operating a business in the United States after the conclusion of employment. So in other words, it's not going to affect any kind of during term non-compete, which that's enforceable typically even in the states that don't enforce post-employment non-competes. Is if your employer says, hey, while you're working for me, you can't go work elsewhere, that's generally enforceable. Going back, so given that definition of non-compete, The rule is that employers cannot enter into new non-competes after the effective date of the rule. It's expected to be about September 4th, 2024, but that's subject to court intervention. Then the next part of the rule is existing non-competes, not just new ones, but existing non-competes are unenforceable following that effective date, except for senior executives. Senior executives are folks that make about 150 grand a year or more and are in a policy making position. We can talk a little bit more about that, but suffice it to say, most employed physicians are not going to be in an organization-wide policy-making position. Things like being a departmental director or on the med staff, stuff like that is not going to impact that. And then even for those senior executives, that's for enforcing existing non-competes. There are not going to be non-competes for senior executives going forward. Finally, employers must notify their workers that their non-compete agreements are no longer in effect and won't be enforced after the effective date. And then one big caveat to all this, in the business sale context, which we can expand to include almost equity ownership, all equity ownership with some nuances that I think we'll get into, the rule does not apply. So if you're a partner in a practice, this is perhaps a different thing than if you're an employee of the same practice. That's the basic framework, Justin.
Interesting. That makes sense. Tell me about the state-specific considerations you mentioned before and how that sort of may create a more complicated patchwork, depending on how this ruling is either upheld or not.
Sure. So like here in California, generally speaking, our not to put too fine a point on it, but our stance matches the FTC's. So in other words, no post-employment non-competes for employees. And so if the FTC rule is invalidated, in California, nothing changes because the base rule of the state still applies. However, the SEC has been very clear that other types of restrictive covenants, including non-solicitation agreements and confidentiality and proprietary information provisions, are still valid. So even here in California, where we don't have enforceable non-competes for employees, employees can't steal your trade secrets, which could include a patient list or referral source list. And that would be part of the confidentiality provision. And then you can even have here in California, arguably, depending on the state of the law, it's not totally clear, but you can likely have patient non-solicits in California. The patient can still choose independently to come see you, but you can't actively go after them. And generally, though, I do think other employee non-solicits that you can't try to poach the staff of where you just worked, or including the physician staff, those are also enforceable. So just remember that those things probably continue to apply even if the FTC rule is upheld.
One of the reasons I think this exists, the non-compete historically has existed to begin with, is as a proxy for the things you just mentioned, which is the patient non-solicit and intellectual property protection. One of the things I'll be interested to see is like, how hard is it to prove, if you go, especially in a more sort of like IP forward type of industry, like you start your own company or you go work for somebody else and you take some proprietary, business information with you. It's a lot harder to prove that that happened than it is to just say like, you can't work for anybody for 2 years. That's a much easier sort of binary yes or no, you did or didn't work for them. It's like, what was in that briefcase you carried out on your last day? All of a sudden it's there's a lot more onus on scrutinizing. Probably one of the things that'll happen is the IP protection is going to get a lot tighter, and the companies are going to be interested in tracking access to data, and because that's now the only way they can enforce trade secret protection, for example.
No, exactly right. And that's what we see in California, that you wrap because California has these twin pillars of no non-competes, but very, very rigorous protection of IP. And so you wrap it up in California, you typically say you cannot solicit patients using the company's the practice's confidential information, and confidential information will of course be defined as including the patient list. So yeah, we're absolutely likely to see lots of things like that.
So for doctors right now who are looking at this, beginning of September sort of ruling deadline. And, I saw the Chamber of Commerce, I guess it is there's pending lawsuits, and the smart people are saying that this is going to be pushed for a ways. How should we be processing real world decision making right now today with the employment agreement that's in my hands based on what I'm seeing in the Wall Street Journal?
Right, absolutely. So there's at least two suits filed in Texas right now, basically challenging that the FTC has overstepped its rulemaking authority. And as you mentioned, the U.S. Chamber of Commerce has filed. I think another group has filed. Both of those suits are before judges that have done nationwide injunctions banning enforcement of administrative rules until litigation is settled. And the Supreme Court right now is also exhibiting some willingness to probe agencies' rulemaking authority. And there's some cases this summer actually before the Supreme Court that may have some relation to how a lower court would analyze this. So basically, with that in the background, it could be a couple years before we really have clarity on that. So, given that backdrop, if you're an employee now, I think given the uncertainty surrounding the judicial challenges, the best tact at the moment, if you're signing a contract, is to follow your attorney's advice as to the non-compete's likely enforceability under state law. If the FTC rule is upheld, great, you'll be free of that non-compete. If not, you will have planned for it. You'll plan for the worst. Obviously, that's probably not what most physicians in that situation want to hear. But I think that advice likely holds even if you're choosing between one or more offers, primarily based on the non-compete. And obviously, you're not going to delay, and your employer is not going to delay a decision on that offer for this to percolate through the judicial system. But I think being conservative is the best way here, just so you don't get stuck banking on something that ultimately may not transpire to your benefit.
Makes a lot of sense. If I try to look at this through an objective lens, which is difficult for me because I've talked to so many doctors who have been absorbing the carrot or the stick rather than the carrot
right.
in their employment arrangements. For me, this is like, oh my gosh, finally. But also, if I think about it in terms of like the structure of the executive, legislative, and judicial branch, this feels a lot more like a law that just got passed than it does like an enforcement through one of these departments that is, their job is to enact the law. I think. I mean, I'm not a politico,
it's been a while since I took administrative law, so I don't want to overstep my bounds here. But the goal is basically administrative agencies engage in rulemaking, which should be filling in the gaps in legislation. Yeah. Congress cannot delegate its authority to legislate to an agency. So that'll be part of the debate that goes on in these court cases. Is it really legislation dressed up as rulemaking, or is it legitimate rulemaking?
It'll be interesting to see what the Supreme Court has to say about that too.
Sure, if it makes it there. So,
yeah. Okay, so you mentioned a couple things. Let's talk about there are exceptions for nonprofits. A lot of physicians are employed by nonprofits. Do you have any sense for, is that relevant in this discussion, like the difference between being a for-profit employee as a physician or a not-for-profit employee as a physician in light of this ruling?
Yeah, for sure. So the issue is this is based on the Commerce Clause. And essentially, the FTC does not have jurisdiction over nonprofits. So that means that if you are working for a nonprofit, this theoretically does not apply to your employer. Now, you'd still have the baseline of state law rules, which likely do apply to your employer. But one of the very interesting twists here is the FTC has said they're not going to determine whether your employer is a nonprofit or not by its tax-exempt status. So in other words, the FTC is willing to probe, yes, if on paper you're a 501c3 or whatever kind of tax-exempt organization, but at the end of the day, they can tell the purpose of your group is to make a profit. And many nonprofits do like to make a profit at the end of the year. They may actually apply this to you. So there's going to be, just because, like I said, your IRS tax exempt organization, there's going to be a subset of those organizations that the FTC may still find that the rule applies to.
Wow. That is creating a lot of complexity. That seems kind of like arbitrary. Because the tax ID is like a pretty clear line, I think, right? And now we're saying it's going to go to somebody's desk, and they're going to, I guess, use their best judgment. That's interesting.
Yeah,
That
and
also means
it's
that
interesting what they mean because, like I said, most nonprofits I see are not purely charitable institutions without a view to their financial soundness. In fact, you could argue that that would be irresponsible and they wouldn't last as a nonprofit very long, right?
right.
So it really depends on what they mean by the organization operating for a profit as that gets fleshed out, because I would think that almost most nonprofits that have been around for a while are around because they keep an eye on their financial statements.
So let's talk about some of the stakeholders here, because in healthcare and amongst physicians and different type of healthcare organizations and practice models, there's a lot of different perspectives even on this single issue. So maybe can you help us think through for the different participants in this ecosystem, what kind of impact may this have both in the short term and the longer term?
Yeah, for sure. I think as far as most employed physicians, this is likely to impact, if upheld and subject to our nonprofit exception, and I think mid levels as well. Note that I don't want to delve too much into this, but those senior executives could be private practice leaders. So if you are a leader in a private practice that sets the business direction of the private practice, you could be held to a non-compete as an employee. That's probably mostly immaterial because you're likely held to a non-compete as an owner too, wearing a slightly different hat. But I think it's going to apply basically to most employed physicians and mid-levels. It's also important to realize that tangential industries, health tech workers, for instance, a lot of the technology companies involved in healthcare, including large EHR companies, they have their workers under non-compete that prevent them basically from working in health tech, which is a massive, burden on those folks' prospects going forward. We also have, particularly in the anesthesia space and in a lot of other practices, depending, a lot of other specialties, depending, you have owners of their own practices or slightly larger practice groups, owners in surgery centers, ASCs, and things like that. For the most part, we do not expect this to apply to ownership. So for sure, if you have a non-compete when you leave your practice and your shares are bought back, same thing in an ASC, most likely that non-compete is enforceable.
Are there any other states that are like California in the way that they think about non-competes?
There are, candidly, I'm not up on the day-to-day, sort of legislative progress, but there are a number of states that have outright banned non-competes beyond California. There are states that have banned non-competes, particularly for physicians. So even if generally they enforce them, they may not for physicians. And then there are states like, I think New York actually had a case where it refused to enforce a non-compete against anesthesiologists, basically on the argument that no one's picking what hospital they go to based on who's going to be doing the anesthesia during your procedure. So even on a state level, we're seeing both legislation and courts also, willing to look at non-competes a bit more rigorously. But I don't want to say that that's universal. It very, very much depends on the state.
I didn't know that New York ruling happened. I have long maintained that was the only way that could conceivably be reasonably interpreted, because I've never picked an anesthesiologist. I don't know. I'm sure you haven't either.
Right.
So.
Well, and we have this, and that's why I sort of said they're mainly used as adhesive retention policies, right?
Yeah, right.
It's, what's the other hand on that? Well, make your employees happy, right? But it's the same thing. You can make the argument for almost all sort of hospital captive specialties, hospitalists, radiologists, anesthesia. I'm sure there's others I'm leaving out, but all those folks generally, if they go to another hospital, they're not pulling away business and using and deploying some kind of secret organizational sauce at that new facility against the old one. It's just it's not what happens.
As it relates to the rulings in Texas that you mentioned, the decision is being made in a court that has the ability to create, you said, a nationwide injunction. Did I properly understand that?
Yes.
So a state judge in a case in a particular state can put the brakes on everything for everybody pending additional legal scrutiny.
Yeah, but it's a federal judge in Texas. We're getting a little beyond, I'm a deal and transactional lawyer, so we're getting a little bit beyond my federal jurisdiction understanding. But I would say it is conceivably possible that you could have dueling federal district courts with different rules. And so theoretically, you could have the rule invalidated in Texas, but upheld in Florida. And then as that percolates up to the courts of appeals, you could have the appellate court split. And that's usually when cases go to the Supreme Court, is if there's split circuits.
Got it. Let's talk a little bit about the implications of this rule as it relates to transactions and M&A and sale of a business and partnership, because it's, as you noted, there's a whole separate set of considerations there.
Sure. I think for M&A, we're pretty clear that the ban is directed to relieve employees, not owners. And it does not apply in the bona fide sale of a business, no matter the ownership level. Initially, the rule had proposed, I think, a 25% ownership level, but they backed away from that. And the reason I say bona fide is you cannot do an M&A deal just to put everybody under a non-compete, right? It's got to be a real transaction. But that's the sale of a business context. It's a little bit different with partner buyouts because that's not exactly the sale of a business. You're selling a part of the business, but not the whole thing. Generally speaking, the FTC has indicated that the exclusion would likely apply to those non-competes. The sort of twist there with a buyback transaction is typically the non-compete is really a springing non-compete. It's found in the practice or the ASC operating agreement or shareholder agreement. And what that means is it's agreed to before the buyback happens, hence it's springing. So there's some commentators that have sort of suggested that there is a little bit of cloud about that and whether or not the rule would allow those. Generally speaking, though, I think it's pretty safe to assume that the rule would allow you, even if you sign a non-compete to join a partnership in year 1, and then you get bought out in year 5, and that partnership agreement that you initially signed had a non-compete, that's most likely enforceable.
Makes sense. What other questions have you had clients of yours bring to you, or what other things to think about that you've observed?
I think we've gone over a lot of it. I mean, the real one right now is sort of what to do if you're faced with that employment agreement, or certainly that partnership agreement right now that has a non-compete. If it's the partnership agreement, I say read it. I would assume that nothing has changed for you. The employment agreement context is a little tougher, particularly where you see folks that, they grew up in a certain area, all their families in a certain area. They would love to go work there, but the employer has a couple red flags and they're scared about being X'd out of the geography in the event the non-compete's enforceable, where they could go to another state and not have a non-compete. And that's just a very hard discussion. I think it's a gamble right now to decide if this is going to hold up.
Yeah. So cultivating a couple options is always your friend there, and do locums for a while it all shakes out. It's not a bad option either.
Right. Although we'll see how extended this process is. Locums for a couple of years may not be everyone's cup of tea.
Certainly. Well, Scott, it's been a pleasure chatting with you. Thank you very much for joining us today on the show.
Yeah, absolutely, Justin. Thank you for having me again, and happy to come back anytime.
If you liked what you heard this week, head on over to apmsuccess.com, where you can find more content and free resources to help you build a successful career in anesthesia and pain management. If you wanted to leave a review in iTunes, I'd also really appreciate it. Thanks for using some of your valuable time to join me today on APM Success.